folks, there are three basic things that a business lawyer does. They monitor the client's legal and regulatory environment. And the second thing is advising and counseling clients, answering their question. Then last but not least is managing the client's business transactions. The business lawyers sometimes don't get no respect. Thank you to Rodney Dangerfield for that. Many business people think they know as much law as we do. A lot of drafters, whenever there's something going on that's very aggressive or very tricky, they put it in the miscellaneous section because they figure...
Welcome, and thank you all for joining us for another Justia webinar. My name is Nina, and I'll be the moderator for today. Now, to kick things off, I want to go ahead and introduce our speaker, Cliff Enico. Cliff Enico is a leading expert on legal and tax issues for entrepreneurs, known for hosting Money Hunt on PBS and writing the syndicated column, Succeeding in Your Business. He is also the author of multiple books on entrepreneurship, crowdfunding, and small business law, as well as legal treatises for Thompson and West. With a 45-year legal career, he has represented over 15,000 small businesses and previously worked at top New York City law firms before establishing his own practice in Fairfield, Connecticut. He is a Dartmouth and Vanderbilt law graduate and an active speaker, YouTube host, and contributor to Entrepreneur and other business publications. The webinar that you're about to watch will be approximately 1 hour, and Cliff will be taking questions from the audience once the presentation is complete, time permitting. So if you have any questions that come up, please feel free to submit them by clicking the Q&A button in the control panel at the bottom of your screen and sending them in there. Now, without further ado, here is Cliff to discuss what business lawyers do, a primer on the practice of corporate and business law outside the courtroom.
Hey, thanks, Nina. Thanks for the wonderful introduction, as always. Okay, well, first of all, welcome to everyone. Thank you for spending a portion of your day with me. This is a program that I have done in one form or another since 1989, believe it or not, and it's very, very close to my heart, for reasons we'll talk about in a minute. But first of all, I guess a quick disclaimer before we get launched here. Basically, what we're going to be talking about today is very subjective. There really is no one right or correct way to practice business law. What we're going to be talking about today, it's a very personal program. It's going to be things that I have learned in the 45 years that I've been doing this for a living. Some of the things you won't find in the books. There is no right or perfect way to practice business law. Some of you, the fact that I may be doing something different than what you were doing does not mean that either of us is doing something wrong. So let me just make a disclaimer about that up front. This is not like the nuts and bolts programs that I usually do for Justia, and other CLE providers. So let's launch into this. Why do you need this program, especially if you've been practicing business law for a while? Because law school doesn't teach this stuff. When I went to law school in the fall of 1977, I had a vague idea that I wanted to be a business lawyer. I kind of knew that I didn't want to be a litigator, fighting courtroom battles off this time. I had a personality that probably wasn't very well suited for that. I also knew there were certain areas of practice, such as tax law, that I probably wasn't well suited for as well. I've always been fascinated by entrepreneurs and working with entrepreneurs and startups and early stage companies. The idea of being somebody, a CEO's right-hand person, helping them, navigate the legal environment was very, very attractive to me. I saw myself in that role, kind of like a gray eminence, the person behind the scenes, who's making everything happen. But I really didn't have a clue what business lawyers actually did in their day-to-day lives. And law school, at least back then, and I think this hasn't changed much in 50 some odd years, that hasn't changed all this much. It hasn't. It hasn't. What law school teaches you is the law. They teach you you read a lot of 18th and 19th century cases, and you do come away with a very thorough understanding of why certain things are done certain ways, but you don't really have any hands-on experience. When I graduated law school in 1980, I couldn't even draft a simple will from my parents, because I just didn't have that kind of training. It's the internship and residency that you do with law firms when you graduate law school that really teaches you and trains you on this stuff. And I was on Wall Street for 10 years, before I went off on my own. Why did you want to become a business lawyer? I mean, is the goal to get rich? Is the goal to work in a company? It's a good question to ask yourself, really. Something I probably should have done. If you're looking at this program and you're not in law school yet, or if you're in law school, you may want to talk to some corporate lawyers about their day-to-day life. Take them out to lunch, or have them take you out to lunch. They got bigger expense accounts than you do, and see what they say about their lives. Do they like it? Do they enjoy it? What do they do every day? What is it like to be in an office, grinding out documents 14 hours a day, 6, 7 days a week? You may love it, you may not. But there are things. The thing I want to stress is that what I do is not litigation at all. This is not a program for business or corporate litigators, because I've never done it. I've only been in court twice in my life. Once was to be sworn into the New York bar in the spring of 1981, and the second was to be sworn into the Connecticut bar in the fall of 1990. Those are the only two times I have ever seen the inside of a courtroom, other than jury duty, of course. That's the only times I've ever done it. Um, okay, and there we go. Okay, two-step process. Okay, there are different types of business lawyer. There's first of all the one that most people know, which is the business lawyer in private practice. The people that work for a firm and are in the corporate department, or the business law department, or in some firms it might be called the contracts department. There is the corporate or in-house lawyer. This is many large corporations have fairly large legal departments. In the early 1990s, I worked for a couple of years for a very large investment bank as an inside counsel, and they basically had one of the largest law firms in the United States in-house at this company at that time. There is the lawyer by training business executive. Quite a few business lawyers decide that they don't want to practice law at all, that they'd rather be on the business side of thing, and that can be done, although it's increasingly difficult to do, to make that transition. And then last but not least, the staff attorney for a government or administrative agency that basically is enforcing the gazillion of government regulations that we have at the federal, state, and local levels. These are the people that I refer to as business lawyers. And we'll get into some detail about how these people look at life a little bit differently. But right now I just want to lay out some of the basics. There are three basic things that a business lawyer does. And these three things we're going to track throughout the entire hour that we are together. They monitor the client's legal and regulatory environment. That is a very important skill, and it's something that you don't always get, even if you're practicing in a firm. The idea is that when you have a client, it's a relationship. This is not a one-off thing. You're not like a personal injury lawyer who fights a battle, either wins or loses, and then they go on to the next client. You may be with this company. I've got clients who've been with me for 30, 40 years, and they somehow have managed to stay with me. They haven't fired me yet, so I must be doing something right. And part of my job is to make sure that I'm ahead of things and that I'm anticipating what their legal needs are going to be. That's the first thing. The second thing is advising and counseling clients, answering their question. A client calls up, you got to have an answer to the questions. And there's a very specific way you have to do that. Then last but not least is managing the client's business transactions, their deals. Business lawyers are sometimes referred to as deal lawyers in large cities. They handle mergers and acquisitions, hiring and firing employees, dealing with consultants, supply chain agreements, all the sorts of agreements and contracts that the business needs to stay functioning. What determines the functions you will perform? Well, there are a number of factors. One is age. When you're first starting out and you're working in the bowels of a large law firm, you're probably going to be spending most of your time on the third thing, which is managing the client's business transactions. The more senior lawyers are the ones who are going to be, answering clients' questions, although you may be doing the research behind the answers to those questions. And certainly monitoring the client, staying on top of the client, attending their board meetings, finding out what's going on. That will almost always done by more senior lawyers. The type of client, there are some clients that are extremely contract heavy. I represent a number of software companies, and just about every week of the year, I'm doing a contract for them. There are other clients that are not as contract specific. A lot of retail brick and mortar businesses. Yes, there are still a few of those around, and I represent a few of those. They may only have one or two things they need me to answer in the course of a year. I'm not doing a lot of track work for them on a regular basis. Then last but not least is the legal environment. Certain clients need more legal services than others. I have clients who I formed 30 years ago. I haven't heard from them since, and then they called me last week and asked me to help them sell their business because they're getting ready to retire and move to Florida or Texas. There are clients that I do every week because the nature of their business or the nature of the legal environment is such that that they need a lot of my services at a particular time. So there's no one answer to this. I want to talk a little bit about some mindsets and perceptions when it comes to where do business lawyers fit in the spectrum of business person, business lawyer, litigator, outside counsel. There's a spectrum here, and the question is, where are you going to fit on the spectrum? So let's talk about litigators, business lawyers. Business lawyers, especially those that work in-house for corporations, are sometimes not viewed as not authentically lawyers. And there's actually some justification to this. I'm working right now on a 50-state survey of how each state defines the practice of law. And it's actually fascinating. There are only one or two states in the entire union that say that by statute that you must have a law degree to draft contracts, give business advice to corporations, and do the three things that I just talked about on the last slide. Only one or two states say that you have to have a law license. Certainly accountants give a lot of business advice to their clients. They do a lot of the stuff that we attorneys do, and frankly, sometimes they do a better job of it because they understand the tax code better than we do sometimes. In-house counsel especially are often viewed as passed over associates. And there is also some justification of this. Most in-house counsel are attorneys who've worked with outside counsel for more than 2 or 3 years. Usually it's 5, 6, 7 years. They're getting close to partnership. They see that they're not on the inside track, and so they move in-house with one of the firm's clients. And the firm is very happy that they did that. Because now they have somebody on the inside that's sort of a friend of the firm and will refer business to the outside. But there's always that perception that you weren't good enough to make it on the outside. So that's how you ended up there. It's just something you have to be aware of. I'm not saying it's fair. I'm not saying it's right. But these are some of the prejudices that happen within our community. Lawyers versus business people. Business lawyers sometimes don't get no respect. Thank you to Rodney Dangerfield for that. Many business people think they know as much law as we do. See, surgeons and doctors have it a lot easier. If I tell you you've got a problem with your spleen and your spleen has to come out, you are not going to second guess me. All right, you may go to a second doctor and get a second opinion. Understood that. But you're not going to come and say, wait a minute, I don't think you should do it that way, doctor. I think you should do it this way, that way, the other way. You're not going to do that because let's face it, at the end of the day, you cannot perform surgery on yourself. Okay, no matter how good, you can be the best surgeon in the world, but you can't operate on yourself. Okay, business people don't look at what we do the same way. They think, well, wait a minute, this is just common sense with some Latin names thrown in. We know this stuff as much as this guy, Enico. There is that attitude, and you got to be aware of it. Litigators versus business people, now they get a lot more respect. When a client is sued and they're in court, it's much more like going into surgery, where they're much more deferential to what the litigators have to do. There's strategy, there's tactics, and most business people are aware that they don't know that stuff. But when it comes to the stuff that we do, they think they know it. A lot of my clients certainly think they can draft contracts as well as I can. And that's something I have to constantly have a dialogue with them about. Business people versus business lawyers. When I was working in the early 90s for that big investment bank, the business people used to refer to the inside lawyers as the Department of Sales Prevention. That is how they looked at us. Our job was to kill the deal. Our job was, we were sort of like goalies, in a hockey game. Our job was to prevent the puck from getting through to the net. That was how they see us. Again, these are just perceptions. They're not always real. They're not always right, but they exist, and it's something you have to deal with when you're dealing with business clients. So these are how your clients are looking at you. This is how your clients are looking at you. The typical path of a career of a business, unlike a lot of attorneys who sometimes go straight into private practice, it's very difficult to go into private practice as a business lawyer directly out of law school. Most people who practice in this area go to work for large firms in the nearest big city to where they live for a number of years, usually 3 to 5 years, sometimes longer. Usually within 2 to 3 years, you decide whether or not you want to be a lawyer or not. And if you don't want to be a lawyer or not, that's when you probably will make a move to go either in-house or leave the law entirely and do something else with your life. If you stay with the firm a little bit longer, when you get to 5, 6, 7 years, it's very, very hard. It's much harder to make a transition to a non-legal career. People will perceive you as a lawyer and they will treat you accordingly. But it is possible to go with a corporation or something like that, and then or just launch your own practice at that time. I did all three. I worked for two large firms on Wall Street during the 1980s. I worked for the investment bank for 3 years in the early 90s, and then I hung out my shingle. I went right to a solo practice. I did work. I was an of counsel to a firm in Southern Connecticut for a couple of years just to get my head back into private practice again. But once I saw that I didn't really need them, I just, left and started practicing out of my spare bedroom, which is where I've been now for the last 30 years. And so, okay, so now let's go through the three things. Let's drill down now. The three things that business lawyers do. Let's talk about how you do those. Okay. Monitoring the client's legal environment, both external and internal, and I'll explain to you in a minute what that means. Your goal is to develop a long-term relationship with the business client. These are clients that hopefully will stay with you for most or all of your entire career. For that to happen, you have to have a thorough understanding of its business, what it does, how it does it, its industry, and things that are changing, that are affecting that industry, its constituencies, its employees, its vendors, its customers, the people involved who make the business happen. Its corporate culture, very important. Some companies have corporate cultures that are extremely aggressive. People are working 80, 90 hours a week. There are some that are very laid back. What is the corporate culture of the client that you have? Do you fit that corporate culture? And the people and the internal power structure. Who's who in this company? Not everybody, these people are not all equal. Certain people in the company are more important than others, and it's very important to understand that power structure in order to be effective when you're advising a business client. So the external environment of a corporation or a company is what's going on in the world outside of the company. What is the legal and regulatory landscape? What's changing? I represent a lot of eBay sellers and Amazon sellers. These are people who sell goods on eBay, Amazon, Shopify, Etsy, and other online platforms. You can bet your sweet bippy that they are lying awake at nights worrying about the Trump tariffs right now and how that's all going to impact their product sourcing. A lot of these people source goods from China, Southeast Asia, and those places are being clobbered right now with the Trump tariffs. How do they navigate that? Do they increase prices? Can they eat some of these prices? They're all wrestling with those kinds of decisions. Keeping the client informed of developments in their field, because things change. I have been approached over the years by some cybersecurity clients, people doing crypto kind of things, and I've kind of downplayed them. I kind of said, well, I really can't help you a lot with that because frankly, the regulatory environment is very hostile to that. Since the Trump administration came in now, they're very favorable to crypto clients. So there's been a sea change in that. I'm spending a lot more time these days learning a lot more about crypto and how that and where that is going. I do have some clients doing fintech, and they're all trying to figure out how crypto interacts with their operations. Anticipate the client's needs before you get the call. Clients love it when they call you and they realize you're already up to speed on what it is that they need. Staying a little bit ahead, anticipating and notifying the client in advance to say, hey, by the way, these things are changing. You may want to think about X, Y, and Z. You may want to think about updating your privacy policy, this kind of thing. If you have time, let's have a chat. Now, there's some ethical dimensions to that, but it's very important to let the client know you care about them and you are ahead of where they are. Take the initiative to solve the client's legal problem. Don't wait until they call you and then say, "Oh, well, it's going to cost you, $10,000 to answer this question. Let me know. I'll get back to you." That doesn't impress them. What impresses them is they call you and you've already got the answer, already worked out. Maybe because you had to do it for another client, but they really appreciate that when you show them that you're on top of things, that they're dealing with a lawyer of the 21st century and not the 19th century. the internal environment is what goes on inside the company, corporate and mostly corporate governance, how the company is run. Historically, the secretary of a corporation, the person that ran the board meetings, the shareholders meetings, and kept all of the corporate records of the company, traditionally was usually someone with a legal background. The general counsel of the company was almost always also the corporate secretary in most big companies. That's changed over the years, but historically that has always been the case. So for a small company, I mean, I work with mostly privately held companies. I don't do work with public companies, but basically preparing agreements among the client's founders, supervising these meetings of the client's directors and shareholders, amending the client's, foundation documents, their certificate of incorporation, their bylaws, when important changes occur. So, for example, a venture capitalist makes an investment in your client, and you now have to add a class of preferred stock to the capital structure. These are the kinds of things that business lawyers get involved in. For public companies, it's all about SEC filings. When they hire a new officer or director, for example, there's a Form 3 that has to be filed with the SEC. When they do an offering of securities, there are Form Ds that have to be filed with the SEC. The general counsel of a public company is almost always an SEC securities law specialist, because that's 90% of the work that they do for their clients. For private companies, not so much securities work. It's mostly contracts and other, documents between shareholders agreements, operating agreements for LLC, that kind of thing. So that's when I talk about monitoring and say the basic lesson here is it's not enough to just sit on your desk and wait for the client to call you. You have to be on top of what that client needs done. Okay, so now let's talk about advising and counseling business clients, which is the second big area of big category of things that business lawyers do for their client. So now the client calls you up and they ask a question. Okay, now, but before you give the answer, there's a lot of stuff you have to ask here. That's why people sometimes, business clients are sometimes a little reluctant to talk to their attorneys because they know they're not going to get an immediate answer. I'm going to ask a gazillion questions before I give them the answer that they're looking for. Hopefully it's the answer that they're looking for. Who is asking the question? Okay, it's a very important thing. Is the question coming from the CEO of the company, someone lower down? If so, whom? Does that person have the authority to ask the question? These are questions you have to ask when you represent a corporate or a business client. Is it one of the shareholders? Now that gets tricky. Does the shareholder, the shareholder owns a piece of the company, but they are not always involved in the management or operation of the company. Is a shareholder doing something behind the CEO's back that he wants to get you on board of? There's a lot of politics that goes into representing a corporate client, and we'll talk about that a little bit later on. Understanding the client's question. When a client asks a question, they don't know the important information to ask you, the legally significant information. And here's where your law school training is actually helpful. You have spent 3 years of your life in law school reading cases, and every time you read a case, you have to separate the wheat from the chaff, the important things, the important facts that led to the court's holding, and the stuff that they disregarded. What did the court listen to? What did the court not listen to? This is what you do. You got to do the same thing when a client asks you a question. What is the legally important information, and what's just general background information that you can bill for, certainly, but you can't really, it doesn't really help you to get to the answer. What's really going on here? What's really going on here? Is there an ulterior motive here? What is the client really looking to accomplish? Remember, I was viewed, when I worked for that investment bank in-house, I was viewed as the sales prevention department. So a lot of times a client would ask me a question in such a way that they were leading me to a certain answer, but that may not have been the right thing for the company to do. So I had to keep probing and getting more information until I finally found out, okay, I see what's going on here, and I know why they're asking the question. Okay, the good news is you can do what you want to do. The bad news is you're going to have to do it a completely different way. So go back and read and redo this. The inarticulate or duplicitous questioner. Sometimes these clients, whenever business people have a phrase, whenever they need to talk to their in-house lawyers, they say, let's run this by legal. And that's great. I love that metaphor. They're running by the door. Oh, by the way, Cliff, here it is. Okay, thank you. Bye. Well, that's exactly how they do. They interface with their in-house lawyers. That's exactly how they do that. The idea is to run it. They don't want us to focus on it because they know when we focus, we're going to drill deep and we're going to find out what's really going on, and we may not let them do what they want to do. Okay, that happened all the time when I was in-house. Every client question is two separate questions, and both of which must be answered. I have to say, I have never been asked in 45 years of practicing law and answering, God knows, hundreds of thousands of client questions in my career, probably millions. I have never had a client say, so Cliff, here's what we're thinking of doing. What does the law say about this? Okay, I don't think I've ever been asked that. If somebody ever did, I think I dropped it. Really, they don't really want to know what the law is. They figure you practice law, you've been around for a while, you went to a good law school, you graduated, you worked for a big firm for several years. You should know, what the law says. I don't have to tell you what they want to know is, what should we do? Okay. J.P. Morgan, the robber baron from the 19th century, had a great saying. He said, I do not pay my lawyers to tell me what I cannot do. I pay my lawyers to tell me how to do what I want to do. And that is the way you answer client questions. You have to look at the question, not just, well, what's the legal analysis here, but what does the client want to accomplish? Can they go this route? There's some rocks on this path they're going to have to circle around. You have to understand both of those layers of the question in order to give the right answer. And there are different kinds of questions. Some are purely legal questions, some are business questions, and some are mixed law and business questions, where you have to this is why it's so important to understand the client and to monitor their environment so that you know enough about their world to know how the answer is going to impact the company and the decision that they're looking to make. You can't just answer these questions in a vacuum. The inexperienced lawyer will give a legally correct answer, but one that's absolutely useless to the organization. Again, analyze the client's question. What's really going on? Get all the facts. Don't let anyone run anything by you. Researching the law, and sometimes you can get away with billing for it. Less and less these days. At the big firms, you can, because they're asking difficult questions. They're getting into gray areas. Most of my clients cannot afford to have me spend hours and hours researching a question. And even if I did have the time, they'd say, well, wait a minute, Cliff, you're supposed to know this. You've been practicing for 45 years. Why do you have to research this? I'm not paying for your education here. That's their attitude. And, because they have limited budgets, these clients, these small business clients, you have to respect that. What happens when you can't find the law that supports what everyone else does? This is something that is very difficult. When you practice in this area, you're going to see that the law sometimes says something, but that's not what people do. What people do is exactly the opposite of what the law suggests, and they get away with it. No one enforces these things. How do you deal with those very tricky situations? You can't say to the client, well, it's okay to do it because everybody else does it. Right? As your parents told you, just because Johnny down the street does it doesn't mean that you can do it. But you also, too, you can't just say, well, the law says this, therefore we have to do it, even though nobody does it. I'm going to insist that you do this filing, with the government. It makes you look inauthentic. It makes you look like you don't know what you're doing. Very tough line to cross there. What happens when it's a gray area? Okay. You have a tough decision to make here. I always take the view here. A lot of attorneys are very conservative, and they say when they're in the gray area, just don't do it. Just don't, whatever it is that you're thinking of doing, don't do it. That's the safest course of action. No one will fault you for doing that. And that's okay. But you're not really representing your client well when you do that. If it truly is a gray area, just make damn sure that it is a gray area. Sometimes the correct answer is something like, well, you're in a gray area here. Most people in your situation would probably not do this, but I can't say that it's against the law for you to do this. But there are risks involved in taking this action this way that you want to do. Here are some of the risks that you're going to be facing, but I can't say it's illegal. I can't say, and then make damn sure you document exactly what you told the client. That is sometimes that way the client has the decision. They know they're in a gray area. They know there's some risks. You've disclosed them, but it's up to them ultimately to make the business decision. You do not make the business decisions. They do. And if it truly is a gray area, you're not doing your job by just telling them that they shouldn't do something. Okay. answer both the surface and the real question that the client is asking. This is kind of repetitive. There's a famous old lawyer story years ago when I was a kid. One of the great things were people were trying to break a Guinness Book of World Records. They wanted to be the first people to cross the Atlantic Ocean in a balloon, and there were a lot of people who tried this. Almost all of them did not succeed. They ended up somewhere in the middle of the Atlantic Ocean or in Iceland somewhere. But this was a big thing. So there was a famous story when I was a young lawyer that two guys are trying to cross the Atlantic in a balloon. They get caught in this horrible storm. They get tossed hither and yon, don't know, the compass falls overboard. They have no idea where they are. All of a sudden, the storm subsides, and they don't know where the heck they are. So they let some air out of the balloon. They lower themselves below the clouds, and all of a sudden they see they're over land. So they want to know, geez, where are we? Are we in, did we blow backwards? Are we in Europe? Did we do it? Did we cross the thing? So they see a guy on a bicycle drive. So they lower themselves for it and they yell out, "Yo, you on the bicycle?" The guy looks up. "Yeah." He goes, "Where are we?" And the guy looks up and he goes, "You're in a balloon about 40 feet above the ground." And he goes on. So the one guy looks together and goes, "You know what? That guy down there, he's a lawyer." He goes, "How do you know he's a lawyer?" He goes, "Because the information that he gave us was 100% accurate, yet totally useless." Okay, that's how business people look at their lawyers sometimes, like the guy on the bicycle telling you something you already know. Okay, can an attorney give purely business advice? The rules of ethics, we'll talk about this a little bit later on, does say that you can kind of go beyond just giving purely legal advice as long as you feel that you are competent to do so and you have relevant background. So certainly if you are a CPA as well as a lawyer, you're certainly competent to give tax advice. And frankly, to be a really good business lawyer, I got to say this, you have to be half a tax lawyer. You really do. And hopefully not a half-assed tax lawyer. Because you are going to get into a lot of tax-oriented questions that have to be. Memos to the file are very, very important. I do them all the time. Whenever you give a client an answer to a question, it's very important, especially a complicated one where we're in a gray area. It's very, very important to do a memo to the file and make sure it's readily accessible in case what hits the fan and they try to blame you for giving bad advice. You want to have a document about exactly what you said to the client, how you sold it to the client, and best of all, send it to the client so it's in their files as well. Lawyer-client privilege applies here. Okay, so now let's go on to the third and the last thing that business lawyers do for their clients, which is managing the client's contracts, their business transactions, their deals. Okay, what do legal documents accomplish? Okay, what are they? Many people would say, well, they're like a blueprint, a plan for how we're going to do a particular thing. We're going to merge two companies. This is how we're going to do it. As a lawyer, I disagree with that. Basically, legal documents, a legal contract is a ticket to a courtroom. That is what it is. As long as the parties get along, as long as there's good communication, once that contract is signed and the ink is dry, they will probably never look at it again. They'll do whatever it is they want to do. They won't even look at the contract. They won't even think to call you. They'll just work things through themselves and everything will be fine. The only time they will ever call you again is when things aren't working out and one party wants to get out of the contract, or they want to change the deal, or they want to do something that is different than what they initially intended to do. One of my favorite sayings, it's one of my favorite quotes. It'll probably be on my tombstone when I die. No one ever calls their lawyer when they're having a nice day. No one does. If everything's going well in a person's life, they don't call their attorneys. They only call their attorneys when the wolf is not only at the door, but has beaten it down and is chopping halfway up their leg. That's when they call their attorneys. Okay, so why do lawyers get involved in doing deals? Well, believe it or not, in years past, they didn't. Back in the 1800s, there was a class of people called scriveners. Who were when you need an attorney, it was because you were being sued or you wanted to sue someone. All attorneys in the 1800s were litigators. Scriveners were a different class of people. They were the people that you went to draft wills, draft business contracts, memorialize deals. Those of you remember Herman Melville, the guy that wrote the Moby Dick novel. He also wrote a novel called Bartleby the Scrivener about such a person. Back then, that's one of the reasons why most of the state's laws today do not have drafting contracts as something requiring a law license. It's this historical background of the scrivener who was not an attorney. What exactly is a transaction? Well, obviously, if it's a deal between two companies and two persons, but it can also be something in the internal environment as well. A contract with a senior manager, their employment agreement, for example. Elon Musk's contract with X or Tesla, would be something. Contracts with consultants, contracts for software development, or supply chain contracts where the client is licensing software or something that they're going to embed in their own product or something like that. A transaction is usually described as a deal, but basically anything that has to be memorialized in a piece of paper is arguably a contract or a transaction of some kind. Okay. Structuring the business transaction, it's always a good idea as a lawyer to be involved at this stage of the game. Most clients wait too long to get their attorneys involved. They negotiate the deal, they put together a term sheet, which is sometimes called a letter of intent or a memorandum of understanding, an MOU, and then once it's signed, they call the attorney and say, okay, now we got to document this. And there's all kinds of things in the letter of intent that were incomplete, not completely thought through, things were missing from the letter of intent. It's very, very important that as an attorney, when your client is doing a transaction, you try to get involved as early on as possible so that you can help shape and structure the deal. Finding out what the client's business objectives are. What are they trying to do here? What is their goal, their business goal? Preparing or reviewing the term sheets or the letter of intent. I tell a client, never sign a term sheet or an L, even though it's a non-binding document. You can change things later. Once you've agreed to something, it's very hard to go back on that, even if it's in a non-binding letter of intent. I want to be involved. I want to make sure the more you can negotiate in the letter of intent stage of a deal, the easier it is to get the documents done. If you're trying to negotiate the terms of the deal at the same time that you're negotiating the legal documents, that's when things get out of control and the legal bills go sky high. Mapping the transaction. Don't be afraid to have your client send you flow charts and examples. Whenever I talk to a client that's looking to do a deal, I have to upload a template to my brain. And once I get that template, that map of the transaction, who's who, who's doing what to whom, once I get that up into my brain, I'm pretty deadly. But until then, I'm pretty stupid. And I have to get to that point before I can say, okay, I get what this deal is about. Now here's what we're going to do. We're going to do this document. We're going to do this thing. We're going to file this with this government agency. Then I know exactly what to do. Until I get there, though, I'm pretty dumb. And I got to get there. I don't want to shoot from the hip and start putting the deal together, not knowing that all the terms have been negotiated properly. Last but not least, get the tax people involved early. One of the biggest mistakes that business lawyers make is they wait too long to get the tax department or the client CPA, if it's a small company, involved. Because I cannot tell you how many deals I've been on where we spent hours and hours, all-nighters, pulling together the document. And at the very last minute, they bring in the tax people to bless the deal. And it turns out that they don't like the deal at all. It's going to create all kinds of tax problems for the client that weren't completely thought through. And they have to restructure the whole deal to make it work tax-wise with only 48 hours to go before closing. I cannot tell you how many times I've been in that scenario as a business lawyer. Whenever I see a deal with an overly complicated structure, knee bone connected to thigh bone type stuff, I know the tax lawyers have been there. Okay. Drafting. Now let's talk about the transaction documents. Okay. So you've been notified of the deal. You've been involved in the structuring. You were involved in the letter of intent. You know what the business deal is. Now it's just a question of getting it on paper. The most important question, who is going to do the drafting? If it's an acquisition, an M&A deal, is the seller's counsel going to draft the docs? Is the buyer's counsel? Whoever drafts the documents has the bigger legal bill. Okay, because this is as true now as it was 50 years ago. The whoever ends up doing the drafting and is responsible for version control, making sure that all the changes are accurately reflected and redlined and everything like that, whoever's got that responsibility is going to have the bigger legal bill, or the most expensive legal bill in the deal. Okay, initial drafts, the correct use of forms and templates. There is no such thing, folks, as a boilerplate agreement. I can honestly tell you, in 45 years of practicing law, not once have I taken a document, a form document, a template available online or in a law book or a treatise or something, filled in the blanks, and handed it to a client as a finished product. I have not done that once in 45 years. Every template, while it's important to use templates to save time, you are the everything. Every contract has to be customized to the individual client's situation and what they are doing. And if it's a contract that I've never seen before, I have to learn how that contract works in order to be able to draft it properly. Here's one of my great quotes. So this is also from one of my books. Show me a form document and that I've never seen before, a frugal framus contract, and I'm ignorant. But show me 2 or 3 different forms of frugal framus contract, and then I'm a genius because I can compare them side by side. I can look, okay, that's common language. That's common language. No, wait a minute, this varies from client to client. Okay, so this gets negotiated. After we work with contracts enough, if you see different forms of the same contract, you'll be able to know exactly what is standard language and what has to be negotiated for the particular deal. Legalese, use it versus plain English. I'm a big believer in plain English, but there are variations to that. So, for example, if I'm doing website documents, terms of use, privacy policy, nobody reads these things. Okay, when was the last time you bought a software product and you actually read the license agreement or the subscription agreement, the online click-through contract? Nobody ever does. There's 2 people that do, though. There's somebody like me who's looking for some sample language for a terms of use document that my client is doing, and I'm looking for some stuff that I can borrow or repurpose for that client. That's harmless. Nobody gets hurt with that, and there's no copyright on legal documents anyway. But the second type of person is a plaintiff's lawyer that's looking to sue your client, and they're looking for loopholes in your terms of service so that they can find out how to sue you and perhaps bring a class action for millions of dollars against your client. Why does anyone bother doing a plain English document when the only person that's going to read it is an adversary, an enemy? I don't get this. When I do terms of use documents, they are the most legalese documents in the world. I don't want that plaintiff's lawyer to have an inch of wiggle room to get through this thing. This thing is so airtight. It's like Fort Knox. You will never be able to break this wall down. Okay, that's what I do. Plain English is great, but it has its limits. Who's the intended reader? Who is the intended audience? There are 3 basic concepts of contract provision. There are deal-specific terms, derivative terms, and boilerplate terms, standard, the miscellaneous section of the contract. A lot of people, this is especially true of leases, commercial leases. A lot of drafters, whenever there's something going on that's very aggressive or very tricky, they put it in the miscellaneous section because they figure the other side's not going to read it. Whenever I see a difficult contract for a complicated deal, the first thing I do is look at the miscellaneous section, and almost always there's something buried in there that's very important that shouldn't be there, that needs to be more front-loaded in the key provisions of the contract. In the long term, there ain't no such thing as a boilerplate legal document. Everything has to be negotiated. You have to look at everything. Do not skim a contract. Make sure you look at all the sections, at least spend a couple of seconds on each paragraph, and make sure that there's nothing in there that nobody is playing any games. The perfect is the enemy of the good here. I mean, the client will always say, oh, I want all these provisions. Here's a 10-page term. I want to get everything here. And by the way, I only want the document to be 3 pages long, and I want it in plain English. They always do. You can't. There's a tension between getting things right and getting things short and simple. And the client has to understand that. You have to educate the client on that. Okay, then organizing the closing. If you are the attorney who's responsible for handling the closing, if it's happening in your shop, okay, the thing I will always tell people is that it's a fire drill. Once the parties have finalized the document, they want to close the next day or the same day. You got to slow it down a little bit. Never, ever allow yourself to be so rushed by a client's deadline that you stop thinking. Because when you do, that's when you make the mistake that's going to get you sued for malpractice, when you allow something to get through into a deal that should not have gotten through, and that it hurts your client. Okay, after the closing, You're the person who's got to clean things up. Who's going to be responsible for putting together all the document drafts and say, thanks to software like DocuSign and Adobe, contracts and stuff like that. You don't worry about that as much anymore. But when you're using DocuSign, make sure that you attach all the exhibits to the contract before you send the DocuSign envelope, because once you send a DocuSign envelope and people sign it, that's it. It's done. You can't go and amend it afterwards. Oh, I forgot to attach the exhibits. Well, now you have an incomplete contract. Congratulations, you've committed malpractice. Okay. Sometimes you have to give a legal opinion. I can give a whole course on opinion letters, preparing and negotiating the bill. I always like the bill at closing, and that's it. So, okay. So let's talk for a few minutes here about in-house counsel. I've kind of referred to in-house counsel throughout the program, but there are some special things you need to know when you're going to work for a company and you only have one client. Okay, that's what you think. You go into house, oh, I'm working for General Motors. I've only got one client now. No, it actually can get a lot more complicated when you go in-house. Okay, are you a business person or are you a lawyer? You're something in between. You're a hybrid. In the Dr. Dolittle books, there's a character called the push me, pull you. That has two. It's like a llama that has two heads. That's kind of what you are when you're an in-house lawyer, and you have to develop a high tolerance for ambiguity. When I was working for that investment bank, every night when I went home, I asked myself, "Now, what the heck did I actually accomplish today?" I was in a lot of meetings. I drafted a lot of stuff. I made a lot of phone calls, but what did I really do today? When you're an outside counsel, you don't have that. You know what you did. You have your timesheets. You know exactly what you did and when you did it. But when you're in-house, it's a little fuzzier. The business people see you as a lawyer, and other lawyers see you as something less than what they are. Okay, remember, there's that perception, unfair though it may be, that as an in-house lawyer, you weren't good enough to make it in the outside world. Okay, there is that perception. Unfair, but it's there, and you have to know that. Are you an individual contributor or a team player? Okay, as an in-house lawyer, you're a loyal member of the management team, and you have a duty of loyalty to the people up on top. But you also have to maintain your professional objectivity. If the CEO wants to do something that's against the law, you have to call them on it and do it in a way that somehow preserves your job. And there's some of the worst ethical opinions and cases that I've ever read have to do with that scenario. You are basically a modem between the executives on the inside and the outside lawyer. You're translating what the outside counsel is saying to the client in language that they'll understand. You're also translating what the client needs to the outside counsel. You are representing the company. The outside lawyers are more the technicians, the surgeons that are going to get the job done. How much direct contact will the client have with outside counsel? Outside counsel, when you're inside, outside counsel can be your enemy. If they have too much contact with the client, they're going to try to cut you out of the middle because they want to develop those relationships, whereas it's you that they should be dealing with. More and more now, in-house counsel are responsible for managing outside counsel budgets. And believe me, they hate you for doing this. They hate that a second grade lawyer, as they perceive you, determines whether or not they get paid and how much they get paid. That's a very tricky situation which you find yourself in. Whenever you are an in-house counsel, you are the monkey in the middle between the business people and the outside counsel. You will need some very tangible skills. Of course, you're a good lawyer. You know how to draft documents and do all that. But the good in-house lawyer is a good communicator, a good manager. You are the repository of the company history, especially if you're acting as corporate secretary. You're the one that is in charge of keeping track of all the contracts and making sure that when we sign this new contract with company A, we're not violating the contract that we already have with company B. You are a strategist, but you're also a sheepdog. You got to have somehow herd the business people, and sometimes you got to knock their heads together to get them to work properly. Here are some of the intangible skills you need as an in-house lawyer. Earning the business people's trust. If they don't trust you, they're going to find ways around you to either deal with outside counsel or try to get things done in such a way that a legal input is not required. Performing triage in managing your workload. There's absolutely no way you can do everything that crosses your desk in a timely fashion. So you got to figure out some things are more important than others. Knowing the centers of power in the organization. Who are the powerful people? And sometimes it isn't always on the organization chart. Sometimes someone who's a little further down the organization chart has real power, and the more senior people defer to that person because of certain factors. That's a very important thing to know. Who knows where all the secrets and all the bodies are buried? I know a lot of companies where the receptionist is one of the most important people in the company. It's not a good idea to get on his or her bad side. Certainly, if you're working for a small law firm, the firm manager, the person who runs everything, that's someone who gets a very good gift from you on the holidays, Christmas or Hanukkah, because that person can really hurt you. They can't help you, but they can really hurt you if they don't like you. Managing outside counsel proactively, accepting that the perfect is the enemy of the good. One of my favorite songs from Bob Seger, it's called Against the Wind. Deadlines and commitments, what to leave in, what to leave out. Who gets calls returned immediately, who gets them returned the same day, who gets them returned later, who gets them returned never. You constantly are in a world where you have to make those decisions. You can't make everybody happy all the time. Being accessible to the right people in the organization, making sure that you're always responding to them promptly and that they like you, and staying out of the middle of office politics. If you see that two of the business people are at odds with each other and they're going at each other, hang back. Don't take sides. Stay back, call them into your office or into a conference room, listen to both sides, offer your input, and try to mediate between the two of them is what you have to do. Don't take one side, because then the other person hates you. And Murphy's Law, no sooner does that other person hate you than they get a big promotion. They're a lot more important than they used to be, and now they hate your guts. Okay. Let's talk now. Finally, we're talking about ethics. I mean, I could do a whole course on ethics for business lawyers. I have done it in the past. We don't have time in 10, 15 minutes to do it. But here are the things. The thing you need to know, the model rules of professional conduct, which were actually adopted in the late 1970s when I was in law school. They're as old as I am. They actually were adopted my third year in law school when I took ethics. And the professor who taught ethics at my school was something of a sadist. Aren't all professors of ethics, sadists at heart? But basically, he said, okay, here's a hypothetical. What results under the Code of Professional Conduct, the CPR, which was the former set of rules, and then would the result be any different under the model rules, which had just been passed, a couple of months ago? Ethics professors are sadists. They are. Okay. But here's one thing that hasn't changed in 50 years. The model rules are meant primarily for litigators, for attorneys who are in adversarial environments. They don't really deal with the sort of issues that business lawyers deal with one exception, Rule 113, which we'll discuss in a minute. When you're looking for ethical guidance, you should look at the model rules, but you should also look at the ethics opinions that have been issued by your state bar association. And maybe you want to look a little further afield to some of the ethics opinions in some of the big commercial states like New York, Illinois, Florida, Texas, California. Look at their ethics opinions, because they're likely to be more sophisticated than what's in your home state. If you're practicing in Montana, for example, you probably want to look at what's going on in Illinois and California, because they'll have more reasoned ethics opinions than the Montana bar is probably going to have. The lawyer's basic duties to the client: competence, confidentiality, diligence, keeping the client informed, no different for litigators than for everybody else. Okay. Rule 113 is the key rule that applies to business lawyers. Who is your client? Okay. Well, according to Rule 113, the organization is the client, which is a great poster to put on your wall, but it's not really very practical, because the organization consists of people, and these people are not always on the same page. There's the organization and then there's human beings. Corporations have three levels of management. There are the officers who do the day-to-day stuff. There's the directors who do the things that are outside the ordinary course of business. Then there are the shareholders who make the big decisions, the birth, marriage, and death decisions for the company. And very often they're not on the same page. Who is your boss? Who do you listen to? Who are the power people? You have to understand the power structure within your client to understand who it is that you're working for and who takes priority over others. You can't really function effectively until you knew that. What happens when the human beings fail to follow your advice? What do you do? special rules for in-house lawyers. One of the most difficult situations you can deal with, I think it's 113E, is the situation in which you discover as an in-house lawyer that, the CEO and the board are doing something that is contrary to the law, and that's going to get them into a lot of legal trouble. Do you have a duty to speak up? The answer is yes. But what happens if they blow you off, or they ignore you, or they pat you on the head saying, "Hey, Cliff, nice analysis here. Thank you. But we're going to do this anyway. Please bring the watermelon to the company picnic," because that's really your job. What do? You are in some cases required by Rule 113E to be a whistleblower. And that's one of the most difficult situations an in-house lawyer especially will find himself or herself in. And in that case, it's very good that you have an attorney working with you who can help you guide you through that. You may have to quit your job to avoid getting into a situation where you have malpractice liability or have an ethics violation. Okay. Monitoring your client's legal environment, the duties of diligence and keeping the client informed. Section, I think it's 2.1 of the model rules. It's okay to volunteer legal information before you are being asked. In fact, it's a very good thing to do. The rule 7.3 basically says you have a duty to keep your clients up to date on developments of the law. So as long as you shoehorn into 7.3, you are not soliciting or doing anything untoward under the ethics rules. When it comes to advising and counseling the client, answering their question, the rules require that the advice must be candid and must be based on independent judgment. The business lawyer's evaluation of a client for use by third parties. Okay. Can you disclose certain information of the client to outside sources without breaching your duty of confidentiality under Rule 7.1 of the model rules? So, for example, there are audit letters. If you're working for a public company that does audited financials as part of its SEC reports, the auditor, the CPA firm, will send you an audit letter, and there's a very specific way that you have to respond to that in order to avoid disclosing information that is confidential. One of my legal treatises, Closely Held Corporations, has an actual section on audit letters and how you respond to them and different ways of responding to different things. That's one of my legal treatises. What happens when the client is located in another state? Rule 5.5 of the model rules says, believe it or not, a lot of attorneys think that they can't practice outside the states where they're admitted. That's not true. The only rule here is you cannot do anything in that other state that constitutes the unauthorized practice of law as it is defined in that other state. Well, remember what I've said now 3 times in the last hour. In almost every state of the union, the work that business lawyers do is not considered the practice of law. In 47, 48 out of the 50 states, I can't remember the exceptions offhand, but you're okay. You're not prohibited from representing a client that's located in another state or that moves to another state. But the only thing you have to do, though, is you have to recall that when you give advice in another state, you are held to the same level of accountability and malpractice liability that an attorney who is admitted in that state is subject to. So if a client moves from New York to California, I might consider that you start taking a lot of CLE courses, join the California Bar Association, do a lot of CLE out there. No, California has some strange statutes, especially involving technology and stuff like that. They have some statutes out there that are unique in the United States. Get familiar with those so that you can fulfill your duty of competence. But you are not legally prohibited from representing a client, from engaging in what business lawyers do. Now, you can't represent clients in court in another state without being admitted there. That's the one thing that all 50 states are uniform and unanimous on, is that in order to represent clients in court, you must be admitted in the courts of that state. But all the stuff that I've been talking about the last hour, perfectly fine in 48 out of the 50 states. Managing your client's transactions, the duty of fairness to opposing parties in their counsel. You must draft documents aggressively. You should draft documents so that they represent your client's provision. You are not a judge deciding what is right or perfect in the deal. Your job is to get your client's interests and your client's goals on paper correctly. But at the same time, you cannot be so onerous and one-sided. If you see that the other attorney is an idiot that doesn't know what he or she is doing, there are some rules in the model rules that say that you cannot take unfair advantage of them, and you need to be aware of that. Can you bluff during contract negotiations? Absolutely. It's perfectly fair. The other side presumably is represented by counsel. Unless, of course, they're not represented by counsel. Now, especially employees. I have had situations where I've drafted a stock option plan for a client, for example, and the client will say, okay, we just put the option plan in effect. Our employees are emailing us left and right. They got all kinds of questions. Can you answer their questions as our counsel? You're the guy who drafted the option plan, so you're better able to answer these questions than anybody else. The answer is yes, you can answer the questions, but what you cannot do is you cannot represent the employee. If the employee needs a change or they need something done a little bit differently, you cannot go to bat for the employee. You have to take the company position. You have to let the employee know you're representing the company. You cannot, if they have an issue, they should hire their own attorney and have that attorney call you, and maybe you can work something out, maybe you can't. Dealing with other professionals, again, when you're dealing with the attorney that doesn't know what the hell. I have been in negotiations where the other attorney was clearly not a business lawyer. It was some local lawyer who handled all of their real estate and their wills or something like that. And they just said, hey, Cliff, I'm going to trust you to keep me from preventing malpractice. I'm going to trust you. You seem like a nice guy. I'm going to trust you. You're not going to do anything that's going to get me sued for malpractice. I'm going to represent my client as best I can, but and I know that I don't know this stuff the way you do. And, I'm going to count on you to be fair in the way you handle this. Wow. They don't train you for that in law school. Okay. Do you owe any ethical duty to that other counsel? You have to look at your state's rules to figure out what's going on. Preventing the unauthorized practice of law, dealing with your client's accountants or CPAs is a very tricky area. I could almost do a whole hour on this. I always try to involve especially when I'm working on a client's deal, and it's a client that I don't know that well, I want to try to involve their CPA very early on. Because they know the tax stuff probably better than I do, but also they know the client better than I do. They've been working with that client for years, and they know where all the bodies are buried. And I'm going to listen to what that person tells me. And in the course of that, I may have to make certain disclosures to that person, even though they're an outsider, but they're an outsider that's also being paid by the corporation. Your client's accountant can be your best friend, or they can be your worst enemies. You really have to read that relationship very carefully, because you need them, but at the same time, if they think you're going too much into their turf, which is a risk for me, I do know a lot of tax law. I'm probably half a tax lawyer in what I do, and we'll be just talking about sections of the code. They may feel threatened by me, and at that point, they're going to clam up. They're not going to tell me what I need to know to help get the deal done. So be very careful when dealing with your client's accountants and making sure that you're not violating any of the rules regarding confidentiality regarding this. Okay. So we've reached the end of the hour here. These are some of the books that I'm most familiar with. Believe it or not, this is my book. The first book here is the one that I wrote back in 1989. It was later republished under a different title. The publisher went out of business back in the early 2000s. The new publisher didn't want any part of it, but you probably can still get some old copies on eBay or alibris.com. That's a used book website. All the used book dealers in the country subscribe to alibris.com, and you can get a lot of stuff there that's out of print. The very first book ever written for business lawyers, believe it or not, was not written by a lawyer. It was written by a sociologist at Indiana University named Erwin Smigel in 1965, called The Wall Street Lawyer Professional Organization Man. When I was looking to apply to law school, this was the only book that I could find that talked about what business lawyers did. And right before I went to law school, a book came out which actually became something of a bestseller, called The Lawyers by Martin Mayer, which was actually the very first book to talk about, for lay people, what business lawyers did. I referred to business lawyers as being a gray eminence. That's actually a reference to an actual character. Louis XIV had a cardinal that he was very close to, who acted as sort of his secret advisor behind the scene. He's one of those guys who didn't have any power on paper, but he had a lot of real power, and the king always listened to him. I can't remember his name, but he was called the L'Eminence Grise, the Gray Eminence, and Aldous Huxley wrote a book about him. The rest of these books are some books that I have published for myself. Back in the 90s and early 2000s, I did an audio program, which is still available. In fact, if you want, it's called Your Legal Career, Finding Success and Satisfaction in the Legal Profession. It's a 6-hour audio program on how to manage your legal career every step of the way. It was a 6-hour presentation that I gave for Quinnipiac Law School here in Connecticut. Unfortunately, it only exists in cassette format. So while I'd be happy to send you one for $20, you're going to have to invest in a cassette player in order to be able to listen to it. The good news is you can find them on eBay for about $25. That technology you can still get. I just haven't had the time to put that program onto CD or CD-ROM. I will hopefully get to it at some point. Okay, so we have a couple of questions from the floor. I'm going to take some time out here. We have another 5 minutes here, so let's try to answer these. How do you transition from working for a corporation to hanging out a shingle with corporate clients? Well, it takes some time. I mean, the good news is that when I left the investment bank in the early 90s and started practicing out of my house, I had already worked for a big firm, for a couple of big firms in Wall Street. So I knew the discipline of working as an outside lawyer. If you've only worked for a corporation, however, and you're working on the outside, you're going to have to learn how outside lawyers work. So, for example, you're going to have to learn how to do bills, which is something you didn't have to do as an inside lawyer. You're going to have to learn something about billing strategies. I actually do a program for the New York State Bar Association. For those of you who are New York lawyers, I do it every year. It's usually in May and June of each year, and it's called Starting Your Own Practice in New York. And it's an all-day program, and it's we talked mostly about the business side of running a practice. You know, how do you determine what areas of law you're going to be practicing in? How do you bill? What are some of the do and don'ts of billing and collecting from clients? How do you market your practice? All of that stuff you're going to have to learn, on your own. And that's a good place to start if you're in that situation. What practical steps do you recommend when advising a client when insists on proceeding with a plan you believe in legally risky? This one's easy. Basically, what you do is, give them the best advice you can, document it in an email. Now, most lawyers are nervous about email because there's a lot of ways you can get into trouble with email, but here's one area where email can save your life. Okay. When you have this kind of a client, you do an email, you summarize what you told the client and say, hey, Joe, just to summarize, this is what we talked about, right? He says, yep, I get it, Cliff. I get it, Cliff. The minute you do that, you print it out. I'm serious. Print this email exchange out, put it in a folder with the client's name on it, because when the client does what he wants to do and the what hits the fan, the first thing he's going to do is he's going to blame you. He's going to say, hey, Cliff, you didn't tell me about this. You didn't tell me I could get into all this trouble. That's when you want to be able to reach into this folder, pull this email exchange out within 5 seconds, scan it, and email it to the client and say, no, I warned you about this, and here's my proof. Okay, most of us have an inbox with 50,000 things in it. You do not want to take hours and hours looking for the smoking gun email where you said, this is what you should do, and I really wouldn't advise you doing it. Okay, that needs to be in a place where you can grab it in 10, 15 seconds. So printing out and put it the email, and think, okay, so that's just my tip for dealing with that situation. Do you have any tips for reacting to other counsel's death by a 1,000 red lines? Okay, the answer is yes. Basically, the first thing you need to do is you need to talk to your client, because your client is paying for this. And I would say, whenever I see a client, another attorney that has just totally taken one of my documents and just totally rewritten it because he didn't like it, whatever, it's almost always a he, by the way, in that scenario. First thing I do is I call the client and I say, look, the other client here is nuts here. They're trying to justify their existence here. Could you please talk to the other side? Tell them, I'm happy to respond to every one of these 1,000 comments, but it's going to cost you a couple of hours of my time. Could you please call the other side and see if maybe they can get this guy to back down a little bit? Because I mean, I'm happy to do it, but I don't want to charge you for it. That's the first thing I do. And if the client blesses it, if he has an unlimited, well, that's what you're in business for. Time is money for lawyers, and the more hours we bill, the more money we make. So, you're gonna have a nice fat payday at the end of the day, although you may have some late nights between now and then. Okay, last question. In your experience, what traits makes an in-house lawyer effective as an organizational translator to both executives and outside counsel? The answer is good listening skills and good political judgment skills, I think. And if you've worked for a big firm for 8 or 9 years, you probably haven't had a lot of experience with that. That is something you're going to have to pick up, or maybe you're a natural politician from the get-go, and this is something that comes very easily to you. But it's something you have to learn very carefully. And again, knowing who's who. Knowing who, not all people are in the organization are equal. If you're in a situation where you're dealing with person A and they're having a conflict with person B, who's the more important person here? Who's the person who's in the strongest negotiating position, and who's the person who's going to win this fight? You have to have those kind of skills to be able to feel that. You don't come out and say, well, I'm going to side with Joe because frankly, he's your boss and he's more important. You can't say that, of course, but you kind of have to know that and sort of guide the conversation in such a way that the person who is the more important person in terms of your career development, that's the person who should win the argument, and you should try to make that happen. Okay, here are some of the legal treatises that I've written. If you go to the Thomson Reuters site here and type in my last name, you should get a listing of all the books that I've written. Or you can look at my bio on Justia, which lists them all. And then here, last but not least, is where you can find out about me. If you have a question for me, I will be happy to answer the question, but I may not get back to you for a day or two, only because I'm very busy. And if I can't answer your question, I'll try to point you to a resource, either a book or a person who can answer it for you. But just realize you're not going to get a quick answer, but I always try to find at least a couple of minutes every day to respond to questions that I get from my CLE program. So with that, Nina, I think we're done. Thank you very much again for letting me do this program. It's one that I'm very close to my heart personally, and I wish all of you best of luck in your practices. I think some of your questions were more career questions than what do business lawyers do questions, but that's fine. You'll see I got a couple of books on how to manage your career too, which you will find very helpful. Thanks again, Nina, for the opportunity.
Thank you so much, Cliff, for your presentation and for answering all of our audience questions. And thank you all so much for submitting your questions. We want to thank you all so much for joining us for another Justia webinar. As I mentioned earlier, we do have a great tool to help enhance your professional presence, the Justia Lawyer Directory. If you haven't claimed your free profile yet, you can visit lawyers.justia.com to get started. With millions of monthly visits, it's a powerful way to connect to high-value leads for your practice. And you can even use our free Justia AI Bio Enhancer to help you write a biography that displays your expertise. If you're looking for even more exposure through our Justia Lawyer Directory, we also have our premium placements, platinum for top spots and gold to appear above the organic listings. If you'd like to learn more about those and the visibility they offer, you can visit marketing.justia.com. Thank you so much for your time and have a wonderful rest of your day. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.